Hello, everyone, and welcome to week 9. We've got about 3 weeks to go to finish our unit, and that must be welcome news for all of you. Well, it's not really news, but it's something that's pretty welcome. In this lecture video, we're going to be talking about the legal issues that are normally encountered in relation to alternative dispute resolution. In particular, in this lecture video, we're going to be focusing on the principle of confidentiality and what that means. We're also going to be looking at the immunity of third-party neutrals, so those who lead mediations or conciliations or arbitrations and so on. Let's begin by talking about the principle of confidentiality. You can imagine that when people undertake alternative dispute resolution, they can do this either through negotiations or through any of the ADR processes we've previously discussed, such as mediation, conciliation, or arbitration, which are the dominant forms of alternative dispute resolution. We realize that it's important for the parties as well as everyone else involved to be able to discuss things in confidence. So, for example, if you were to negotiate with another person, with the opposing party in relation to a dispute, and you are aware that any offers of settlement you might make, any admissions you might make, or any statements you might make at all can potentially be used against you as evidence in any court proceeding, then you or the other participants would be pretty hesitant to actually engage in discussions. There would be difficulty in being, engaging in discussions with candor and honesty and openness because of the possibility that any statements you make can be used against you as evidence. And in the context particularly of alternative dispute resolution processes where there are third-party neutrals, imagine a scenario as well where not only the statements you make, but the behaviors you undertake or the actions you make, such as you becoming angry or perhaps being perceived as unreasonable, could then be used against you in the course of legal proceedings. Then this would then be a process that would be pretty scary and would appear to be very concerning for the parties involved. And this is the reason why we have the principles of confidentiality, which we will discuss in a short while. The other thing we ought to consider as well when we talk about confidentiality so I've discussed confidentiality in relation to negotiations, which can be outside of mediation, conciliation, or arbitration, or court proceedings. In other words, prior to any legal processes or the commencement of a civil action, the parties may on their own informally discuss and negotiate. So that's one aspect during which the principles of confidentiality will apply, and the rules and the principles of confidentiality in relation to the confidentiality of negotiations are actually distinct from confidentiality which govern actual ADR processes. And as I mentioned, the third aspect would be confidentiality, for example, in terms of the communication between a lawyer and his client, or a lawyer and another party. And we are aware about the rule of professional legal privilege, during which means that any discussions or statements or exchange of communications between a lawyer and a client are privileged communication and can be used in a court of law or in any legal proceeding. It's embedded in the common law. But one of the questions we need to ask as well is that what then happens if a client perceives that he has been given wrong advice by his or her lawyer? And if the principles of confidentiality apply, then it means that there would be no evidence on the part that that a client may adduce against his lawyer because of the principles of confidentiality. Or what if in the course, given the principle of confidentiality, for example, if there might be communication between a lawyer and a client, and some of these communication may appear to border on an unethical conduct, in the sense that there might be threats and so on, will those be covered as well by the principles of confidentiality? And so these are some of the questions we're going to be examining in this lecture video. And so on completing this topic, you should be able to discuss and explain the rationale for protecting and the limits on confidentiality, the liability of third-party neutrals, and the immunity that protects them, and the legal basis for enforcing settlement agreements as well as how dispute resolution clauses may be enforced. I won't get into that fourth subtopic about how dispute resolution clauses may be enforced because otherwise this is going to be too lengthy a video, and I would therefore encourage you to either go through your textbook or read the study guide. So I'm just going to be mainly covering the first three parts of these learning outcomes. Okay, so I've essentially traversed the principle of the importance of the principle of confidentiality, saying that, imagine a scenario where the principles of confidentiality do not apply in relation to negotiations or ADR processes, then it would be pretty clear that the parties and even the mediator or a third-party neutral would be pretty hesitant to engage in open and honest discussions and candid discussions about a legal dispute for fear that that will lead to legal liability or could be used as evidence in any court proceeding. So that should be pretty apparent to us. Now, the question, though, is what exactly is covered by the rules of confidentiality? For example, does it mean that, for example, if there were negotiations between parties, does it mean that anything said in the course of negotiations would be covered by the principles of confidentiality, or are there exceptions to the rule? What if, in the course of negotiations, there are statements that are mentioned, but these relate to a different matter? Would that be covered by the principles of confidentiality? So these are some of the things we're going to be examining as well. Are there exceptions? What if there is tortuous conduct that is then committed? If there are crimes that are committed, will those constitute as exceptions? We're going to be looking at those questions as well. And how is confidentiality really different from the principle of legal privilege? And what then would be the legal basis for the principle of confidentiality? So we're going to be discussing these points in greater detail in the succeeding lecture PowerPoints. Okay, so going back to the importance of the principle of confidentiality, it should be pretty clear that public interest in the resolution of disputes outside of the court system would require the principle of confidentiality, because otherwise, as I mentioned, it would be really pointless to engage in open and honest and candid discussion and negotiations towards a possible settlement dispute if any statements or any action that is undertaken in the course of those events can be used in a court proceeding. And the full and frank disclosure and discussion towards resolution of a dispute would apparently be important drivers for there to be confidentiality of all discussions towards settlement or in the course of ADR processes. We know as well, or we should be aware as well, that when there are disputes, there can also be commercial disputes. And some of these commercial disputes actually relate to multi-million dollar or even multi-billion dollar commercial disputes, especially when these may involve trade secrets. And you can just imagine, therefore, that if the principle of confidentiality were absent, then again, the parties involved in a dispute would be very hesitant to discuss the facts, to talk about what the issues are, what the underlying interests might be, if they know that any information that is disclosed in the context of negotiations or ADR processes may then be used in court or in a business transaction. So so these are some of the main reasons why the principle of confidentiality applies. But we will realize that even though the principle of confidentiality applies, it cannot be used in order to pervert the course of justice, as we see later on. So it can be used in order to shield the commission of a crime or the commission of a tortuous conduct. So we're going to be examining these issues in a short while. Okay, so confidentiality, what exactly is covered by the principle of confidentiality? So at its core, when we speak of confidentiality, it means that anything said or done is not intended for public knowledge. It's meant to stay within the four corners of a room. If it were a room that had four corners, if it were a room that was circular, apparently, it should stay within the walls of that room. So it's not intended to be used in any court proceeding. It can't be used for the purpose of profiting from any disclosure in the course of negotiations or ADR processes. Now, the question, though, for example, I mentioned already that when you talk about negotiations can happen outside of court processes, meaning outside of any legal proceedings that have been commenced, or negotiations can happen when civil proceedings have already commenced. We recall in the previous weeks that there is such a thing as court-annexed ADR or court-ordered ADR. In other words, you can have alternative dispute resolution as part of court proceedings. And the question then is in relation to negotiations which can occur during court-ordered or court-annexed ADR processes. Would those negotiations mean that even the conduct of the parties would be covered by the rules of confidentiality? Or would the rules of confidentiality be different if it's done outside of what we know to be ADR processes? Because remember, negotiation by itself is also an alternative dispute resolution process, and you can have negotiation outside of court proceedings, or you can have negotiation as part of court-ordered ADR. In other words, when we talk about mediation or conciliation or arbitration or some other ADR process, in order for there to be a resolution of the dispute, the parties apparently have to negotiate. Otherwise, they're going to have to leave it to an arbitrator or an adjudicator or a judge to make a determination about the respective legal rights of the parties. And then it will be for the judge or a third-party neutral, an adjudicator or an arbitrator to make a judgment as to who is right or wrong. And so if the parties are uninterested in having a judge or an arbitrator or an adjudicator making a determination in relation to what the legal outcome should be about the legal dispute, then the parties apparently have to negotiate. And the question then is, what rules of confidentiality apply in the context of negotiation as part of ADR processes? So we're going to look at that. And then how about the rules about non-disclosure of information to any third party? Are there limits, admissibility in legal proceedings, and the use of information, and so on? Okay, so let's begin. So as I mentioned, there are actually three parts to the principle of confidentiality. I'd like to break it up along those lines. One is that the rules about confidentiality during negotiations between parties outside of court proceedings or outside of court annex or court-ordered ADR is distinct. And the principles here are often governed by what is known as without prejudice communications. There can also be, the second part would be confidentiality during ADR processes, which, as we will see, actually have broader rules on confidentiality. And then there's apparently confidentiality between the lawyer and the client, or what is known as professional legal privilege. Okay, let's begin with the first rule on confidentiality, which is often couched in terms of the without prejudice rule. Now, when I say that it's without prejudice, it is often commonplace that when there is communication between the lawyer of a party who engages in negotiations or discussions with the other party or with the lawyer of the other party, it's commonplace for any such communications to have a statement without prejudice. What it means, therefore, is that when that phrase is used in any communication without prejudice, it signals to the other party that any discussions, any statements made are meant to be treated in confidence. It also means that it cannot be used in any legal proceeding. And as we will see, that is actually protected by the common law. So at its core, when you talk about confidentiality, the without prejudice rule, it means that the communication during negotiations to effect a settlement cannot be admitted to evidence without the consent of the parties to that communication. Now, bear in mind, therefore, that if you were to really strictly apply the rule, what actually happens if the parties end up having an agreement? So there is one of the parties or the lawyers of the party sends an offer to the other party, and then the other party accepts the offer. Now, if you follow the principle of confidentiality, it means that the offer and the acceptance of that offer can't be used, can't be adduced as evidence because of the principle of confidentiality, right? Let's get back to that in a short while. But in any event, when we apply the principle of confidentiality as part of the common law, there are three elements that have to be there. One is that there has to be a litigious dispute in existence between or contemplated by the parties. In other words, there has to be a legal dispute already. Secondly, the communication must be made with express or implied intention that the communication would not be disclosed if the negotiations fail. So it can be expressed, such as by the statement without prejudice. It can also be implied. In other words, it is actually possible for statements to be made in the course of negotiations, and even if the parties actually fail to expressly state that any discussion are to be treated in confidence or covered by the rules of confidentiality, or even if the parties do not actually use the phrase without prejudice, for as long as these three elements about the common law principles of confidentiality exist, then they would still be bound by the principles of confidentiality. And the third element apparently is that the purpose of the negotiation is to effect settlement. Now, again, let me just clarify, in relation to this particular confidentiality, in relation to the without prejudice rule, we're discussing this in my lecture video in the context of discussions outside of the typical dominant ADR processes such as mediation, conciliation, or arbitration. There's a lot of interaction apparently, but the rules of confidentiality in relation to negotiations between the parties outside of mediation, conciliation, or arbitration, or even outside of court proceedings are distinct, because the rules of confidentiality that govern when there are ADR processes involved are much broader. So the ones where there are ADR proceedings that are being used by the parties, the rules of confidentiality there, as we will see, are actually much broader. Okay, so I've already signaled that when we speak about confidentiality in the course of negotiations, it is in the context of negotiations. And what we're doing now is to examine what is the basis, the legal basis for the application of the principle of confidentiality. One is, at its core, apparently, would be by agreement of the parties. So it can be expressed or implied, or, like, we're going to have discussions now. You talk to another party, we're going to have discussions now, but this has to be treated in confidence. Or it could be signaled by the fact that, these are without prejudice discussions. So when those statements are made, it means that there is an agreement between the parties that what they discuss and statements they make as part of discussions toward a settlement will have to be governed by the principles of confidentiality. So one of the legal bases would apparently be the agreement of the parties. Now, in the case of Lukey versus Andrew Plea number 2, case decided in 1994, this again shows that the rule of confidentiality is actually embedded in the common law. So in other words, even if the parties fail to call to the attention of the other party that their discussions are meant to be treated in confidence and that the rules of confidentiality will apply, the common law will still protect the discussion or the negotiations and apply the rules of confidentiality even in the absence of the agreement of the parties following the common law. And in this particular scenario, where the question was whether there were two letters from the solicitors could be received in evidence for a determination by the court of costs. And the court ruled that the parties intended the conference to be without prejudice. It was in the interest of the public that the parties be encouraged to resolve disputes outside of court. So here, even though none of the parties actually called attention to the fact that the discussions towards a negotiation were to be treated with confidence, the fact remained that the court recognized that the parties intended the correspondence to be without prejudice, and therefore the rules of confidentiality will apply. As the court said, if the parties have attempted to settle the whole or part of the litigation, and if they have agreed between themselves expressly or impliedly that they will not give in evidence any communication made during those discussions, then public policy makes those discussions privileged from disclosure in a court of law or equity. In the case of Rush and Tompkins Limited and Greater London Council, this involved a subcontractor who wanted to discover the correspondence between the plaintiff, Rush and Tompkins, who are building contractors, and the council, because the subcontractor felt that they should be aware about the settlement agreement between the main building contractors and the council. And the court, the Privy Council ruled that the without prejudice rule generally makes inadmissible in any subsequent litigation proof of any admissions made with a genuine intention to reach a settlement. So any proof of any admissions made, any statements made in the course of where there is any genuine intention to reach a settlement are covered by without the prejudice rule. And admissions to reach settlement with a different party within the same litigation are also inadmissible, whether or not settlement was actually reached with that party. So you can see the broader application of the without prejudice rule to apply even to third parties. And public policy required the protection for genuine negotiations, and also required that genuine negotiations should not be disclosed to third parties. So at common law, the rules of confidentiality clearly apply. Now, what are the exceptions? There are also exceptions recognized in the common law about in relation to the principle of confidentiality. One is that the communication is not objectively part of settlement negotiation. So if there are outside admissions that do not genuinely form part of settlement negotiations, as we will see later on, these will not be covered by the rules of confidentiality. And you also cannot use the principle of confidentiality in relation to an unqualified admission concerning objective facts. So in other words, if there is an objective fact, you can't just bring it up in the course of negotiations in order then for none of the parties to be able to testify as to the existence of that objective fact. So you can't use the principle of confidentiality to say, oh, because I've now raised this in the course of the principle of confidentiality, then you cannot discuss this. This cannot be raised in the course of legal proceedings. No, that's not permitted. If it is an objective fact, even if it arises in the course of negotiations, if it involves an unqualified admission concerning an objective fact, the principles of confidentiality will not apply. Again, because you can't use the principle of confidentiality in order to just obstruct justice or prevent the testimony or proof in relation to an objective fact. The other exception would be that the communication is not about the same subject matter as the negotiation. So apparently, when you can have negotiations, you might be talking about different things, but the principles of confidentiality will only apply in relation to the same subject matter. There's also protection under the Australian consumer law that triggers action under that particular act, and this means that if one of the parties engages in misleading and deceptive conduct, the other party who has engaged in it can then say, oh, but because we discussed this in the course of negotiations, then you can't bring it up in court. So in other words, you might have a consumer, it might be you, dealing with a store, for example, or a manufacturer or a distributor or a retailer in relation to a product that has been sold. And it might be that the consumer has a concern about warranty or a product defect, and there are negotiations then as to whether or not the consumer can claim a refund or claim a warranty and so on. And in the course of negotiations about how the store or the trader might resolve the dispute that has been raised by the consumer, there might be misleading or deceptive conduct that is made by the trader. But if that trader engages in misleading and deceptive conduct, the principle of confidentiality will not apply. It will not shield the trader or the businessman from using the principle of confidentiality in order to shield, any misleading or deceptive conduct. The other exception is that if the communication constitutes an offer and acceptance, and thereby there is a contract, apparently the principle of confidentiality will not apply. So under the common law, when there is an offer and the offer is accepted, at that very moment when there is a meeting of the minds between the parties, then there is a contract, or there is a valid contract or a valid agreement upon the parties. It doesn't even have to be in writing. It could be done orally. It could be done by gestures. In other words, when people do a handshake to signify or symbolize the fact that they have reached an agreement, then there is a valid and binding contract between the parties. Now, if we say that the rules of confidentiality will apply, in all cases, it will then mean that when there is a valid contract between the parties, then the contract cannot be adduced in evidence, but there is clearly an exception. So when there is a contract, then Mabel, you need to lower the volume. When there is a contract, then it means that that is not ruled, that is not governed by the principles of confidentiality. When the conduct also constitutes criminal conduct, then the rules of confidentiality will not apply. So in other words, in the course of communications, where there might be unlawful threats or any conduct that might be considered to be criminal, that again will not prevent evidence from being adduced and covered by the principles of confidentiality. It can happen that in the course of two parties, for example, I'm using it, Mabel, stop it. It might mean that in the course of negotiations between parties in relation, for example, to a family law matter, both parents of a minor child might enter into negotiations and discussions about child arrangements. And in the course of doing so, it's potentially possible for one of the parties to engage in what might be considered to be domestic violence. Any statements made therein cannot be covered by the principles of confidentiality. It is an exception. When the communication is also intended to prevent the court from being misled, then the exception will also apply. When the communication constitutes tortuous conduct, then again, the rules of communication will not apply. For example, in the common law, in relation to the law on torts, it is possible for example, for an individual to make a statement, and on the basis of that statement, the other party will rely on that statement. And if it turns out that that statement was intended to mislead the other party, or on the basis of negligence, it leads to damage on the part of the other party, and in those circumstances where there was a breach of duty of care, in that case, the principles of confidentiality will not apply, because if the communication constitutes as tortuous conduct, then the rules of confidentiality will not apply in that instance. Okay, so a scenario where it can be shown that matters which are not really part of the settlement agreements are not covered by the principles of confidentiality are demonstrated in the case of Field and Commissioner for Railways, New South Wales. In this particular case, during an examination, Field, the plaintiff, had told the medical examiner that he had left the train while it was still moving. So there was a medical examination by a medical officer. In the course of medical examination, the plaintiff said, "Oh, I left the train while it was still moving." And this actually was the reason why the plaintiff was injured. And the question was that statement made the medical officer covered by the principle of confidentiality? And the answer was no. because at that point, the settlement so at some point, the settlement negotiations failed and the matter went to trial. The question was whether the medical examiner could give evidence of what Field had said, or whether the statement had been made in the course of settlement negotiations. And the court said that Field's statement had not been made in the course of settlement negotiation, and therefore, the admission fell outside the area of protection. It was not reasonably incidental to the negotiations. Nobody also expected the plaintiff to discuss the cause of action with the doctor, and therefore the doctor's report was not relevant to settlement negotiations. Rather, it was wholly for the purpose of providing a medical opinion at a hearing should negotiations fail. So again, this was in the context of admissions or statements made with a medical officer. But if it had been a different scenario, had, for example, the plaintiff perhaps been talking to somebody from the railway station in order to discuss, potential legal liability on the part of the railway station, which was actually covered by the law of torts, for example, or these had been discussions with a lawyer of the other party, those would have been covered by the principle of confidentiality, but not in the scenario where the statements were actually made by the plaintiff, statement made to a medical officer in the course of a medical examination. So it wasn't clearly the medical officer had nothing to do with possible settlement with the plaintiff. Okay. Now, so we've discussed that the principle of confidentiality in relation to negotiations are governed, or the legal basis thereof would be agreement of the parties, either expressly or impliedly. It's also enshrined under the common law, but there are also statutes that actually provide that discussions towards settlement or negotiations towards settlement are covered by the principle of confidentiality. Under the Evidence Act, for example, 1995 Commonwealth, under Section 131, subsection 1, it provides that evidence is not to be adduced of a communication that is made between persons in dispute, or between one or more persons in dispute and a third party in connection with an attempt to negotiate a settlement of the dispute, or a document, whether delivered or not, that has been prepared in connection with an attempt to negotiate a settlement of dispute. The Evidence Act of 1995, Section 131, subsection 2, it provides, however, that the principles of confidentiality will not apply if it is with the consent of the parties of the disclosure, the substance has been disclosed with the parties' express, implied, or implied consent, there is partial disclosure with express or implied consent, and full disclosure is necessary to enable proper understanding of evidence adduced thus far. The communication includes a statement to the effect that it was not to be treated as confidential. Material tends to contradict or qualify evidence already admitted. It is in a proceeding to enforce an agreement between disputing parties for settlement of the dispute. The evidence already adduced is likely to mislead the court unless the evidence in dispute is adduced to contradict or qualify that evidence. It is relevant to determining the liability for costs, and making the communication, such as preparing the document, affects the right of a person. And the communication was made in furtherance of commission of fraud or an offense, or it is a deliberate abuse of power. So there are exceptions, again, to the rules on confidentiality. Okay. So we've covered the first part, which was confidentiality during negotiations, and we're now going to be looking at the second aspect of confidentiality, and this relates to confidentiality during alternative dispute resolution processes. So here, when we speak of ADR, we're essentially looking at ADR such as mediation, conciliation, or arbitration. Although, as we already know, negotiation is an alternative dispute resolution process. It's a way of, resolving a dispute outside of legal proceedings. And we also know that even when you have mediation or conciliation or even arbitration, the parties can resolve a dispute by themselves through negotiation. So here, this is distinct. We're not speaking of confidentiality during actual ADR, where there is a third party neutral. So confidentiality during ADR is actually protected or is actually emphasized on the basis of statute. For example, under the Civil Proceedings Act of 2011, Queensland, under Section 53. Evidence of anything done or said or an admission made at an ADR process about the dispute is admissible at the trial of the dispute or in another civil proceeding before the court or elsewhere only if all parties to the dispute agree. So it's clear that if one of the parties objects, then the rule of confidentiality will have to apply. Subsection 2, in subsection 1, civil proceeding does not include a civil proceeding founded on fraud alleged to be connected with or to have happened during the ADR process. So the rule of confidentiality will not apply where there is an allegation of fraud. So you can't use the principle of confidentiality to shield the commission of fraud or the commission of a crime. So that is an exception there. Under the Federal Court of Australia Act of 1976, Commonwealth, Section 53B, it provides that in relation to admissions to mediators, evidence of anything said or of any admission made at a conference conducted by a mediator in the course of mediating anything referred by the court under Section 53A is not admissible in any court, whether exercising federal jurisdiction or not, or in any proceedings before a person authorized by a law of the Commonwealth or of a state or territory, or by the consent of the parties to hear evidence. So evidence of anything said or any admission made at a conference. It's much broader because it's evidence of anything said. So in other words, even if the statement is outside of the subject matter of the dispute, but for as long as it was done in the course of an ADR, that will still be covered by the broad application of the principle of confidentiality. Under Section 54.1, there is a requirement as well of the Civil Proceedings Act 2011 Queensland that an ADR convener must not, without reasonable excuse, disclose information coming to the ADR convener's knowledge during an ADR process. This also provides a protection to the parties that even if any statement they make or any action or the kind of behavior that they demonstrate, the ADR convener or the mediator cannot testify later on against any of the parties. So the rule of confidentiality is not just about statements made, it could also be potentially conduct of the parties, because it's possible that in the course of ADR processes, one of the parties may become so angry or behave in a way that can be shown that one of the parties might be unreasonable. And there is therefore the danger that where raw emotions are involved, those conduct can potentially then be adduced in evidence, not by the parties, but by an ADR convener. But that is prohibited under Section 54, because as that provision provides, an ADR convener must not, without reasonable excuse, disclose information coming to the ADR convener's knowledge during an ADR process. In under the Civil Proceedings Act 2011 Queensland, Section 54, subsection 2, it provides that it is a reasonable excuse to disclose information if the disclosure is made with the agreement of all the parties to the ADR process, or for the purpose of giving effect to this part, or for statistical purposes, not likely to reveal the identity of a person to whom the information relates, or for an inquiry or proceeding about an offense happening during the ADR process. So where there is an offense, the rules of confidentiality will not apply. So in other words, in the course of an ADR proceeding, if somebody then ends up committing battery or assaulting another person, the rules of confidentiality will not apply. Or for a proceeding founded on fraud alleged to be connected with or to have happened during the ADR process, because it's possible that a person may make fraudulent statements or mislead another person deliberately, the rules of confidentiality will not apply. Or under a requirement imposed under any other act. There are also exceptions provided by the Family Law Act of 1975, particularly Section 10H. It provides that an FDR practitioner, a family dispute resolution practitioner, may disclose a communication if he or she reasonably believes that the disclosure is necessary for the purpose of protecting a child from the risk of physical or psychological harm, preventing or lessening a serious and imminent threat to the life or health of a person, reporting the commission or preventing the likely commission of an offense involving violence or a threat of violence to a person, preventing or lessening a serious and imminent threat to the property of a person, reporting the commission or preventing the likely commission of an offense involving intentional damage to the property of a person or a threat of damage to property, as well as for the purpose of assisting an independent children's lawyer to properly represent the child's interest. So there are exceptions to the rule on confidentiality in relation to family law proceedings governed by the Family Law Act of 1975 Commonwealth. Now, in the case of Wentworth and Rogers, a case decided in the New South Wales Court of Appeal, the claimant Wentworth applied for specific performance of a mediated settlement agreement. The application was supported by tendering the agreement in question. But Rogers objected to tendering of the document due to the requirement for confidentiality under the then provisions of the Supreme Court Act of 1970, New South Wales. But the court held that the only way the agreement could be admitted would be if the court was satisfied the parties to it had consented. But he was not satisfied on the face of the agreement that any such consent was implied in it. And because the agreement contemplated the subsequent preparation of a deed, in other words, there was no valid contract yet, then the judge concluded that the agreement was not final and binding, and therefore refused admission of the document into evidence in the absence of consent from the parties. So the rule of confidentiality applied because that was actually part of an ADR process. Had there been a valid agreement, a valid and binding final agreement, then apparently the rule of confidentiality would not have applied, because if you cannot produce in evidence the agreement, and if you cover it by the principle of confidentiality, then there would be no evidence of the agreement between the parties. But if it was just an offer, or there was no final and binding agreement between the parties, the principles of confidentiality will apply. So we've in relation to confidentiality of ADR processes, we've said that it is provided by the common law. It's also provided by the statute. It's recognized by the common law. It's also provided in statute. But typically, you will have confidentiality as a result of agreement. Agreement not just between the parties, but agreement with a third party neutral. So it's typical for written agreements to have a clause which provides that this mediation is confidential insofar as the law allows. So again, there are limits to the confidentiality, as we have already known about the principle of confidentiality. It can be used to shield fraud or the commission of a crime, or if it shows that there is imminent threat to a child or to another person, the rules of confidentiality, even in the course of ADR processes or mediation, will not apply. Now, an example of a model mediation clause would be something like this: all confidential information disclosed during the mediation or prior may not be disclosed except to a party or a representative of that party participating in the mediation, or if compelled by law to do so, and may not be used for a purpose other than the mediation. Again, we must note that you can have mediation outside of the commencement of actual legal proceedings, or you can have ADR processes that are court-ordered or annexed by the court. When there is mediation or an ADR process that it's court-ordered or court-annexed, there might be specific rules that the court will impose upon the parties that will then be on top of any agreement between the parties or what the statute would provide. According to the NADRAC Guide to Dispute Resolution, information that must be kept confidential can include what you and the other participants say during ADR discussions, including ideas about possible solutions, information created and shared during the ADR sessions, the discussions between you and the ADR practitioner, if you have a private session, phone calls and emails between you and the other participants, your thoughts and opinions about how the other participants behave during the ADR sessions, and reasons why you and the other participants did not reach an agreement. So these are matters or information that are kept confidential by agreement between the parties following the NADRAC Guide to Dispute Resolution. Under the NADRAC Guide to Dispute Resolutions, it also provides that some situations where you may be able to bring your ADR discussions to the attention of the court include where you or the other participants did not act in good faith, there is fraud involved, there is criminal behavior involved, or there are breaches of the law, or the information is from ADR discussions and it is information that is available separately from and independently of the ADR process. That is, the information would be available even if there had not been an ADR process. This is a crucial point, again, because if the principle of confidentiality would apply in any event in relation to any statements or disclosures or admissions made in the context of a mediation proceeding, for example, then one of the parties can purposely or deliberately make an admission in the course of a mediation for the purpose then of ensuring that the rules of confidentiality will apply, which would then mean that no evidence could be adduced in relation to that admission. But in that case, that will actually lead to injustice. So one of the basic principles is that if this, admission could be objectively and independently verified outside of the ADR process, then the rule of confidentiality will not apply. In other words, you cannot use the mediation to shield yourself from any evidence being adduced if that evidence could actually be adduced outside of a mediation process. Okay, so we've talked about confidentiality in the course of negotiations. We've also talked about confidentiality during ADR processes, which, as we've seen, is broader because it covers, when it comes to confidentiality during ADR processes, it covers not just statements made, but also the conduct and potentially the behavior of the parties in the ADR process. The third aspect relates to confidentiality, or what we know to be professional legal privilege, which is also actually enshrined in common law. But it's also enshrined in statute. So, for example, under Section 118 of the Evidence Act of 1995 Commonwealth, and you can also examine Section 119 of the same statute, it provides that evidence is not to be adduced if, on objection by a client, the court finds that adducing the evidence would result in disclosure of. So you notice it's actually on the basis of the objection by a client. Okay, if the use of that evidence would result in disclosure of a confidential communication made between the client and a lawyer, or a confidential communication made between two or more lawyers acting for the client, or the contents of a confidential document, whether delivered or not, prepared by the client, lawyer, or another person for the dominant purpose of the lawyer or one or more of the lawyers providing legal advice to the client. Now, just briefly on this subject as well, we should be aware that the rules of confidentiality in relation to legal privilege does not shield the lawyer if the lawyer ends up making statements that might be unethical or could actually lead to a tortious claim. So, for example, if in the course of providing legal advice, the lawyer makes statements that are wrong, and this leads to damage on the part of the client, that communication between the lawyer and the client can be covered by the rules of confidentiality, because it mainly protects the plaintiff or the client, and the plaintiff can actually waive the rules of confidentiality under common law. And so therefore, the rule of confidentiality will not apply where the client may make a claim against the lawyer on the basis of the commission of a tort, where, for example, there is the commission of negligence on the part of the lawyer, which leads to damage on the part of a client, or when the lawyer may end up engaging in unethical conduct or fraud in dealings with the client. Okay, let's talk about the immunity of a third-party neutral. So the third-party neutral can be a mediator, it can be a conciliator, it could be an arbitrator, for example. And the basis of the immunity of a third-party neutral could be one on the basis of the agreement. So it's typical that before undertaking mediation proceedings, the parties will be required to sign an agreement whereby the third-party neutral is given protection and immunity from possible legal claims made by the parties. So in private dispute resolution by agreement between the parties, it's common that the third-party neutral is immune from legal liability arising from the dispute resolution process. And it can also be by way of statutory immunity, as we see. So, for example, under the Federal Court of Australia Act of 1976 Commonwealth, it provides that a mediator or arbitrator has, in mediating or arbitrating anything referred under Section 53A, the same protection and immunity as a judge has in performing the functions of a judge. Those are broad protections and immunities. Under the Supreme Court of Queensland Act of 1991, Queensland, in performing the functions of a mediator or case appraiser, the ADR convener has the same protection and immunity as a judge performing the functions of a judge. In Von Schultz and Attorney General of Queensland, the Queensland Court of Appeal ruled that a mediator under the provisions of the Supreme Court of Queensland Act of 1991 has the same immunity from prosecution as a judge of the court. Okay, so finally, we're going to be talking now about the enforceability of settlement agreements. So at some point, the parties may enter into an agreement. The question then, an agreement to settle the dispute. And in relation to its enforceability, it could be by contract. It could also be, the settlement agreement could be on the basis of a contract that the parties enter into to settle the dispute, or it could be through a consent order, which essentially means that the parties sign a written document that binds them only if it is approved by the consent. And if it is approved by consent, it is therefore an order that is issued by the court on the basis of consent of the parties. But in a sense, that's conditional on the court approving the document, the provisional document or the provisional agreement entered into the parties. It's provisional because it becomes binding on the parties only upon its acceptance by the court, and the court issuing an order approving the consent order, the draft consent order prepared by the parties. In Pitorino and Maynard, the Western Australia Supreme Court ruled in a situation where there was a mediation. So in this case, a mediation was conducted by a court registrar. At the end of the second session, a handwritten agreement was drawn up that set out the terms of the agreement, and this was signed by all the parties and the legal representatives. In this particular case, one of the parties had complained that the settlement agreement was not valid. She had pain, she had suffered pain, and she needed to consult a lawyer, and so on. But it was ruled by the court that the settlement agreement was actually valid, because under the facts, there was really no pressure on the plaintiff. When the agreement was signed, the executor was never told that the plaintiff was in pain, contrary to the allegation of the plaintiff, or that she was unwilling to sign the agreement. The mediation conducted by the court registrar was conducted with acrimony, but with a clear objective to reach an agreement. The registrar conducted herself in a neutral manner. The plaintiff never said that she was in pain or unwell, and the plaintiff appeared to have good advice throughout the mediation. So the agreement was upheld. Now, but you will notice that one of the reasons why, among the reasons why the settlement agreement was held valid, was that the registrar conducted herself in a neutral manner. In other words, if the registrar or the mediator had not conducted herself in a neutral manner, in other words, there could have been bias that was shown by the registrar, or it could be shown that the registrar was not being objective or impartial towards both parties, then in that particular case, it may be possible for one of the parties to impugn the validity of the agreement as having been procured in the absence of the application, for example, of the principles of natural justice, or the breach of the requirement that the third party neutral should remain neutral. And you will also notice here that the reason why the agreement was upheld was that the court came upon the conclusion that the plaintiff, there was no evidence to prove that the plaintiff was in fact in pain or unwell. But this tells us that if it had been established that the plaintiff was in fact unwell or was in pain and really wanted, for example, that the mediation proceeding be temporarily suspended or be moved to a different date in order for the plaintiff to be able to recover, then and had that not been allowed, then there would be question whether there would have been questions that could be raised as to whether or not the plaintiff actually provided valid consent or informed consent. But in this particular case, the court ruled that there was no adequate proof. On the balance of probabilities, it could be shown that the plaintiff never was in pain, and so therefore the plaintiff was in fact able to provide valid consent. Now, if the plaintiff had also failed to get good legal advice throughout the mediation, or especially in relation to the agreement being signed, then potentially the settlement agreement could have been set aside. But all throughout, the plaintiff was actually represented by a senior counsel and a solicitor. And so therefore, the plaintiff did not want for good legal advice. And for these reasons, the court ruled that the settlement agreement between the parties was in fact valid. And so, on completing this topic, you should be able to discuss and explain the rationale for protecting and the limits on confidentiality, the liability of third-party neutrals, and the immunity that protects them, and the legal basis for enforcing settlement agreements, and how dispute resolution clauses may be enforced. And with that, I thank you for watching this lecture video. Bye.